A major Supreme Court decision just made it much harder for everyday investors to sue when mutual funds break federal rules. The court ruled 6-3 that private shareholders cannot use a key provision of federal investment law to take fund managers to court. Instead, enforcement falls to government regulators. For millions of Americans with retirement accounts in mutual funds, this means less power to challenge how their money is managed. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. An activist investment firm called Saba Capital bought into several closed-end mutual funds and wanted to challenge voting rules that limited the power of large shareholders. Saba argued the funds violated federal law requiring equal voting rights for all shareholders. Saba tried to use a provision of the Investment Company Act of 1940, a law that regulates mutual funds, to sue in federal court and undo the contracts that created these voting restrictions. The lower court agreed with Saba, but the Supreme Court reversed that decision, saying the law does not actually give private investors the right to sue. The fund's lawyers said the provision was written as an instruction to judges, not as a permission slip for investors to file lawsuits. They pointed out that Congress had used stronger language in a similar law decades earlier, and when it rewrote this provision, it deliberately chose weaker words. Think of it as the difference between a shield you use to defend yourself in court versus a sword you use to start a fight. The federal government agreed. Its lawyers said the provision is just a rule telling courts what to do with cases already in front of them, not a way to open the courthouse door to new lawsuits. Saba's lawyer disagreed sharply. He argued the text clearly gives individuals the power to act. He pointed to the phrase, "at the instance of any party," as proof that regular people, not just judges, can use this provision. He also warned that if the funds won, the provision would be pointless since fund managers would never sue their own investors. Justice Amy Coney Barrett wrote the majority opinion. She focused on three main reasons. Her first reason explains that the language is aimed at courts, not individuals. The provision talks about what a court can do, not what people can do. The phrase, "at the instance of any party," means something like, at the suggestion of someone already in the case, not anyone who wants to file a lawsuit. Barrett's second reason highlights that Congress knew how to create a right to sue when it wanted to. The law has two other places where Congress explicitly gave private investors the right to sue. If Congress wanted to create a broader right here, it would have said so clearly. Her third reason reflects on how Congress's editing choices matter. In 1979, the Supreme Court found a right to sue in a similar law because it used the phrase "shall be void." When Congress rewrote this provision, it removed that exact phrase. The majority said removing the words that had supported the earlier ruling was a clear signal that Congress did not want the same result this time. Justice Elena Kagan and Justice Ketanji Brown Jackson disagreed. Jackson, joined by Justice Sonia Sotomayor, argued that Congress knew about the 1979 ruling when it rewrote the law. When Congress added the word rescission to the new version, it was building on that earlier decision, not erasing it. The phrase, "at the instance of any party," creates rights for individuals, Jackson argued, not just instructions for judges. Jackson also challenged the majority's logic about Congress's editing. She pointed out that Congress inserted the exact word rescission that the 1979 ruling had used. That was not a signal to erase the right to sue, she said. It was a signal to keep it. This decision closes off a powerful tool that individual investors had to challenge how their mutual funds operate. From now on, if a mutual fund breaks federal investment rules, you cannot easily sue in federal court to fix it. Instead, you have to rely on the Securities and Exchange Commission, the government agency that oversees investment funds, to enforce the law. For fund managers, this is a win. They now have stronger protection against shareholder lawsuits challenging their governance decisions. For investors, it means less direct power to hold funds accountable in court. The deeper issue here is how courts figure out what Congress really meant when it rewrites a law. Both sides agreed Congress, not courts, should decide who gets to enforce federal law, but they disagreed about how to read Congress's mind. The majority looked only at the words Congress chose and what Congress removed. The dissenters looked at what Congress knew about earlier court rulings and what Congress added back in. This tension between these two approaches will shape how courts interpret federal laws for years to come. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.